Welcome. My name is John Tehranian. I'm one of the founding partners of One LLP, a 35-attorney law firm with offices in Beverly Hills, Newport Beach, and Del Mar, California, where we primarily practice and focus on intellectual property and entertainment law matters. I'm also the Paul W. Wildman Chair and Professor of Law at Southwestern Law School. And today I'm going to be presenting a talk called Banned in the USA, the New Censorship. In this talk, we're going to be examining how, in modern times, censorship has reemerged under a new guise. Copyright law, specifically its utilization in a disingenuous manner, has re-enabled the use of the promulgation of censorship in a way that fundamentally betrays basic First Amendment values. We'll be looking at how this increasingly disingenuous use of copyright law has permeated a variety of places uses on the internet, as well as in the publishing worlds, and talking about some of the damage this does to our robust political discourse and the ways in which we might look at addressing the copyright law as censorship problem. We'll begin by talking about the idea of banning books. Now let's take a general book. It may be a normal book, a work of fiction, say. Poses no threat at all to national security. There's nothing particularly salacious about this work of authorship, nothing ribald about its content, and it doesn't defame anyone, living or dead. In fact, it's entirely fictional. And if this book were banned by some kind of third world dictatorship, we'd immediately be calling for economic sanctions against this country and protesting its violation of human rights and its acts of censorship. We'd be writing letters through Amnesty International and characterizing the incarcerated publisher as a prisoner of conscience. Thankfully, we think to ourselves, this kind of thing couldn't happen to the US. We have a strong First Amendment. We don't ban books. And generally, that's true. However, there's a major exception: copyright infringements. Now, courts, as we know, under the First Amendment, will give broad leeway to protect even the most repulsive and dangerous forms of speech from prior restraint. Famously, courts will not stop neo-Nazis from marching through the streets of Illinois town to spread their message of hate among a sizable population of Holocaust survivors, despite significant threats of violence. Courts won't enjoin newspapers from publishing excerpts of sensitive classified documents acquired through the commission of a felony, no less, despite potentially grave national security concerns. Yet for all of this rhetorical solitude, an impressive body of case law showing just how deadly serious we are about protecting our First Amendment values, even from repulsive or potentially dangerous speech, we have a curious exception to all of this that calls into question our very sense of the First Amendment. We ban books as a country, and we do so regularly. These books you can't find in bookstores, and courts have regularly not given any pause about banning these books. And should someone violate these bans, they'll go to jail. These books are books that are characterized as copyright infringements. Now, in historical times, copyright and the First Amendment did not intersect that much. Traditionally, copyright applied to a work, an entire work. It protected against literal one-to-one reproductions of works. However, in the last 2 centuries, the scope of copyright law has dramatically expanded. It now covers both literal and non-literal takings. And perhaps most importantly, copyright law grants to copyright holders not just the right to reproduce or publicly display or publicly distribute their work, but to also create derivative versions of the works. This derivative works right has been broadly and expansively interpreted. And what it basically means is that individuals who create unauthorized derivative works, works that in fact may contain much of their own speech plus borrowed speech from someone else, those works are subject to being deemed copyright infringement and as a result enjoined from publication. As a result, the modern notion of copyright protection and infringement under the derivative works doctrine can encompass a musical composition that has an original melody and original lyrics, but maybe happens to lift a bass hook from an old James Brown number. It encompasses music with a unique setting and with a unique setting and storyline that happens to feature characters from Star Trek. Or, to take a recent example, it encompasses a fanciful, reverse postmodern Bildungsroman where Holden Caulfield, now a 76-year-old man on the run from a nursing home, confronts his own creator, J.D. Salinger. Now, let's consider this latter case. In 2009, shortly before he passed away, J.D. Salinger, the infamous recluse, came out of hiding, at least legally speaking. He sued an individual named Colting. This was the author of a book under the name John David California. The book was called 60 Years Later, and it was an unauthorized send-up of Catcher in the Rye. Basically, to Salinger, 60 Years Later constituted a clear infringement of his copyrights to Catcher in the Rye. Now, 60 Years Later certainly used the Holden Caulfield character, and it certainly borrowed some elements from Catcher in the Rye, including some literal borrowing of catchphrases and idioms from the original book. However, it had an original storyline, took place many years in the future, and in fact was postmodern in its use of J.D. Salinger as a character within the novel itself. Ultimately, the defendant believed that it had committed fair use and that its activity should be also protected as protected under the First Amendment. However, despite the fair use and First Amendment claims of the defendant, the federal district court ruled in favor of Salinger and issued an injunction to enjoin the publication of the book 60 Years Later. The Second Circuit largely affirmed that holding, and in the process, both courts effectively showed little compunction about what amounted to a prior restraint of a book, a step that would be largely discouraged in almost any other context. To this day, 60 Years Later remains available overseas, but it is banned in the USA. Now, the results of the Salinger case are no outlier. In fact, they're typical. Considering First Amendment issues and copyright is something that the courts have been unlikely to do. Specifically, although courts have disfavored any kind of prior restraint under First Amendment doctrine generally, and have regularly denied applications for preliminary injunctions to suppress even the clearest violations of law, they have shown no hesitation about enjoining the publication of works that are deemed copyright infringement. So, for example, in National Socialist Party versus Village of Skokie, the courts protected the rights of neo-Nazis to march and spread their vicious message of hate. In New York Times v. United States, the courts rejected an attempt under the First Amendment by the government to enjoin publication of the Pentagon Papers, despite claims by the government that these were highly classified military documents whose release could cost American lives. And in Neer v. Minnesota from 1931, the Supreme Court deemed it an unlawful prior restraint to prevent the publication of defamatory content that was also anti-Semitic in tone, that contained racial hatred. And yet, despite all these rulings, the courts have had no problem in banning a variety of copyrighted works from allegedly infringing works from publication. In Salinger v. Colting, of course, the New York courts had no problem granting an injunction to publication, enjoining publication of the follow-up to Catcher in the Rye called 60 Years Later. In Warner Brothers Entertainment v. RDR Books, the Southern District of New York had no issue enjoining publication of the Lexicon, an encyclopedia of all things Harry Potter. In Dr. Seuss Entertainment versus Penguin Books in 1997, the Ninth Circuit enjoined publication of The Cat Not in the Hat, a satirical examination of the O.J. Simpson trial that riffed on some of the tropes from Dr. Seuss's Cat in the Hat. And similarly, other cases have repeatedly found that copyright infringements are subject to potentially being enjoined. Now, as a result, in a strange way, book banning is still alive and well in our very country. But it isn't just the banning of books that copyright's immunity from the First Amendment has caused. And in fact, in recent years, copyright's exceptionalism has grown concerning for entirely different reasons. Specifically and increasingly, putative copyright holders have used infringement claims as a cynical censorship device to prevent the dissemination of unfavorable or damaging information, or to silence political and social opponents. Let me give you an example, and this is a case from the Ninth Circuit called Maya Magazine's v. Monge. In this particular case, we have two Latino celebrities, Noelia Lorenzo Monge, who goes by the name Noelia, a prominent Puerto Rican singer, and her love interest, Jorge Reynoso. They had a problem on their hands. They had secretly wed in a Las Vegas ceremony in 2007, but they had hidden their nuptials from the entire rest of the world and had told their fans that they were single, and they had told the media they were single. But then a tabloid rag obtained actual wedding photos from their ceremony. They obtained these photos from a bodyguard, and suddenly Monge and Reynoso's furtive union was exposed. Now, at first blush, seemingly there was little the couple could do. After all, this was a tabloid reporting on truthful speech on an issue of legitimate public concern. As much as it may not be high value, people were interested in the marital status of Monge and Reynoso. Now, the First Amendment, of course, typically protects news reporting vigorously, especially when it's truthful and it's a matter of public concern or interest. But Monge and Reynoso would not take the outing of their marriage lightly. And so they did with copyright law what they could not do with any other area of law. They made Monge Magazines, the owner of the tabloid, pay. How did they do this? First, they purchased the copyrights to the photographs. They simply got an assignment from the individual who had taken their wedding photographs. Then, they didn't sue Maya for invasion of privacy or any other tort, which likely would have been immunized from First Amendment by the First Amendment. Instead, they sued Maya Magazine for copyright infringement. Why? Maya Magazine had, without permission, reproduced, publicly displayed, and publicly distributed these photographs. Why did Monge and Reynoso file this lawsuit? Well, it wasn't to vindicate any real value in the copyrighted work. Rather, it was a means of suppressing and punishing truthful speech. And the gambit worked. Although a district court initially found that Maya's activities were protected under the fair use doctrine, the Ninth Circuit ultimately reversed and in a published decision deemed Maya liable for infringement. According to the appellate court, Maya's activities basically constituted an unauthorized use of the heart of a series of unpublished creative works for the highly commercial purpose of tabloid journalism. As a result, they had improperly usurped Monge's right of first publication to the copyrighted photograph and therefore infringed copyright law. But Monge and Reynoso's victory came at a significant price to the First Amendment and ultimately to the vitality of our copyright system. By fetishizing property interests in copyright works at the expense of public right of access to factual information, the decision effectively provided future plaintiffs with significant cover for disingenuous uses of copyright enforcement. Lest one think that Maya was just a seemingly frivolous case about a silly celebrity scandal, think about how the precedent could be applied in cases of greater seriousness. For example, against the next publisher of the Pentagon Papers, or any other unpublished material that creates eminently newsworthy secrets. As writer Andrew Baum has cautioned, the case might prevent the press from reproducing emails confirming an affair denied by a general and his book-writing mistress, say General Petraeus and Paula Broadwell, or the same-sex relationships of a gay-bashing congressman. Now, Monge v. Maya magazine is no outlier. It is one of many cases that empowers the law of copyright as a mechanism for the suppression and censorship of speech. Examples of the disingenuous use of copyright law for censorious purposes abound. In recent years, you basically have many political groups using copyright law as a way of censoring their opponents. Consider the world of abortion rights activism, where, for example, in Northland Family Planning versus Center for Bioethical Reform, abortion rights activists brought infringement litigation to enjoin speech by pro-life forces. How? They claimed that they were using their copyrighted campaign materials. In 4 Navy SEALs versus Associated Press, military personnel ginned up copyright claims as a way to suppress photographs from being spread that documented human rights abuses. And in Savage v. Care from 2009, a prominent political talk show host sued to prevent unauthorized reproduction of his broadcast in order to suppress criticism of his hate-filled rants. In short, copyright has a censorship problem. Copyright has become the weapon par excellence of the 21st century censor. Fueled by a desire to prevent one's perceived foes from making certain types of speech, an individual actually has no better friend than copyright law. Copyright violations are ubiquitous. With smartphones in our pockets and network computers at our desks, we have the ability to infringe copyright multiple times every single day. And we leave digital fingerprints to document our infringing activities if a rights holder decides to investigate and has the wherewithal and willpower to pursue a claim. Now, liability under copyright law is massive. It's up to $150,000 per infringing act that is willful. And copyright law provides statutory damages. In other words, the ability to assess damages even when the actual harm from your infringement costs no one anything. In other words, it is ripe for potential abuse. Copyright suits are difficult to fend off. The average suit costs hundreds of thousands of dollars to defend. And perhaps more saliently of all to the sophisticated censor, federal courts have almost systematically immunized infringement suits from explicit First Amendment defenses. In a famous Supreme Court case in 2003, Eldred v. Ashcroft, the Supreme Court blithely noted, quote, "Copyright's built-in free speech safeguards are generally adequate to address any conflict with the First Amendment." However, as we'll see, that's not entirely true. And increasingly, instead of engaging in robust free speech to convince the public of the merits of their respective views, organizations at the front lines of the leading cultural and political issues of our day have waged proxy wars against each other through the prism of copyright law. With the strategic use of infringement claims, they've found a powerful tool to censor opponents. This is clearly not what the framers of the Constitution had intended for the resolution of political differences in the 21st century. Now, admittedly, the disingenuous use of copyright law has not been without some pushback. Some federal courts have responded by providing mechanisms under motions to dismiss to have early resolution of copyright claims where the infringement is clearly excused under the fair use doctrine. And in fact, in other cases, courts have even awarded fees to prevailing defendants as a way of deterring such frivolous suits. However, as the Monge v. Maya magazine case indicates, the response has not been all positive. And although courts have entertained some early adjudication of fair use issues, most have declined. The resulting situation is that defendants with even the most ironclad fair use defenses still have to face back-breaking expenses in litigation, including discovery, just to vindicate their rights. And the courts have also issued troubling and binding precedent to make censorious cases viable. Finally, part of the problem is outside of the hands of the courts. The extrajudicial relief that's provided under the copyright holders of the DMCA has made censorious uses of copyright law without reliance on courts all too easy. Let's start on this latter point, the DMCA. The DMCA is the Digital Millennium Copyright Act. It was passed in 1998, and it concerns several different things. For our purposes, most importantly, is the DMCA safe harbor, which is codified in Section 512 of the Copyright Act. The DMCA safe harbor provides limited immunity from copyright liability to internet service providers that perform certain types of function, including providing information location resource tools, i.e. linking, or providing user-generated content. This last one is very important because user-generated content and the exception for liability for ISPs that provide user-generated content is effectively the thing that allows YouTube, Facebook, Pinterest, Tumblr, and a whole host of other sites to not go bankrupt from copyright litigation. They are immunized from liability so long as they simply act as passive entities that provide user-generated content and they meet certain strictures of Section 512 of the Copyright Act, including obeyance to the notice and takedown regime. The notice and takedown regime under the DMCA says that if a rights holder provides notice to an internet service provider that a user has uploaded content that's infringing, that service provider has a limited time, usually interpreted as approximately 48 to 72 hours, to take down the materials. In addition, the service provider must put together a policy that is reasonably implemented that closes down the accounts of repeat infringers. So they have to take down infringing materials and prevent repeat infringers from continuing to use their system. Under these circumstances, ISPs are then immunized from liability. One can see, though, that the incentives that are given under the DMCA result in the takedown of copyrighted materials upon notice of a takedown notice. However, many takedown notices are flawed. In fact, Chilling Effects, a group that is now known as Lumens, keeps a database of takedown notices that are served under the DMCA to major ISPs. And according to their survey, up to 60% of takedown notices are flawed for one reason or another. Sometimes the rights holder isn't really the rights holder. Other times, the activity is actually not infringing and is subject to a fair use defense. However, ISPs don't have much incentive to consider fair use. When they receive a takedown notice, they have 72 hours to take down the materials. If they do, they've now absolved themselves of liability if the material happens to be infringing. Why take a risk of leaving those materials up if they might be fair use? A question that is remarkably fact-based, upon which there is remarkably differential precedent on the issue, and which if you ask 10 copyright lawyers for an opinion on, you're likely to get 10 different answers. Now let's examine the DMCA issue with some examples. The DMCA takedown regime, of course, requires a copyright holder to take the initiative to notify an ISP about when a work is infringing on its network. The ISP then has 72 hours approximately to take down the materials. There is a counter notification regime built into the system. This is a regime where the user can file a counter notification if they believe the takedown notice is sent in error or makes an incorrect conclusion about whether the materials are infringing or not. However, and this is very notable, a ISP does not have to return the allegedly infringing materials back online until between 10 to 14 days after receipt of the counter notification. What this means is that even if you are a user of a copyrighted work and you have an undoubted fair use defense, if the copyright holder serves a takedown notice to an ISP, your materials will be down for a significant period of time. The timing then of a DMCA takedown can be abused and exploited as a way of silencing your speech, even when you have every right to make it, at very particular junctures. Now, we've seen this in the heat of political campaigns, where not surprisingly, right on the eve of an election, there's a sudden uptick in the use of DMCA takedown notices for the silencing of speech by political foes. One of the most circular, almost comically circular examples of this is the use of DMCA takedown notices during recent political cycles in the gay marriage debate. In 2009, Stand for Marriage Maine, SFMM, a group that supported a ballot initiative to overturn Maine's legalization of same-sex marriage, put together a campaign advertisement shortly before the November 3rd vote on the issue. Sorry, 2008, I should have said. In the spot, SFMM used a 20-second excerpt from an NPR story to advance their viewpoint that legalization of same-sex marriage would mean that kids would be taught about gay sex in schools. Now, to the disappointment of some of its own political allies, NPR successfully used the DMCA to remove this campaign spot from YouTube and other internet sites, effectively eliminating the efficacy of this spot right on the eve of the election. Now, NPR's actions, NPR standing for pro-gay marriage in an action against an anti-gay marriage group, their actions mimic those of some organizations on the same-sex marriage side of the equation who have used similarly disingenuous appeals to copyright law to have materials that are critical of them taken down. The National Organization of Marriage, a nonprofit that's dedicated to the fight against legalization of same-sex marriage, launched a $1.5 million advertising campaign a number of years ago that was called Gathering Storm. And they did so in a number of key battleground states on the eve of an election. When audition footage from Gathering Storm leaked, MSNBC's Rachel Maddow played excerpts on her talk show as a way of criticizing the underlying assumptions and merits of the campaign. NOM did not take well to this leak, and although they could do nothing about it in other ways legally, they decided to use copyright law to effectively have Maddow's bit taken down from YouTube and other websites on the claim that her bit infringed their copyrighted leaked footage. Ironically, National Organization of Marriage has been on the receiving end of DMCA takedown notices by proponents of gay marriage. Famously, celebrity news blogger Perez Hilton, who has himself been on the receiving end of numerous copyright infringement suits, filed DMCA takedown notices to have actual copies of the Gathering Storm ad removed from YouTube. Why? Because those ads contained several seconds of footage from Mr. Hilton's personal video blog. NOM used the footage, and in this case it was footage of Hilton attacking Miss California Carrie Prejean for her response to his question about same-sex marriage in the 2009 Miss USA competition, to argue that same-sex marriage proponents were silencing traditional marriage advocates on illegitimate grounds. In other words, all sides of the gay marriage debate have been exploiting copyright law, not to vindicate any particular value to their copyrighted materials, but taking advantage that almost anything is copyrightable instantly from the moment of creation, and anything, therefore, is eligible for DMCA takedowns if it's used by a third party. They have exploited the DMCA to silence speech. Now, one very dangerous example of using strategic timings of litigation and the DMCA to silence speech came up a number of years ago with radio talk show host Michael Savage. He brought claims of copyright infringement in a suit against something called CAIR, the Council on American Islamic Relations. During his 2007 broadcast of his political talk show, Savage went on an epic rant which critics accused of being laced with Islamophobia. He declared the Quran a book of hate, and he deemed Muslims throwbacks who should be deported without due process. In response, CAIR put together an online critique of Savage's vitriol and encouraged listeners of all faiths to contact companies that advertise on Savage's show to express their concern about his particular anti-Muslim tirade. Now, with the online post, CAIR was excerpting, without permission of course, approximately 4 minutes from Savage's broadcast, Savage's 2-hour broadcast. The use of the broadcast appeared to be a quintessential form of commentary and criticism, in other words, something that would be typically protected under fair use. Nevertheless, Savage filed lawsuit because they had reproduced and publicly distributed his work without permission and claimed infringement. Now, to its credit, the court quickly dispensed with the suit. They granted an early motion to dismiss on fair use grounds. But the court rejected CAIR's request for attorney's fees, and left CARE to absorb its entire fees for defending this meritless suit. The court admitted the plaintiff's copyright action was never strong and was litigated anemically, yet it declined to award fees. By denying CARE fees, the court basically failed to deter the overreach of Savage's claims. So it shouldn't be too surprising that only a little while later, Savage used the same tactic to silence other groups that were protesting his hate speech by using similarly tenuous claims of copyright infringement. This time, he targeted Brave New Films. It was a group that had incorporated 1 minute of his comments, a quarter of what CARE had used, as part of a media piece it had prepared to put on YouTube. Now, Brave New Films had taken out a full-page advertisement in the New York Times with a link to the video. Savage harnessed this timing opportunity to serve a takedown notice. What did he do? He served a takedown notice to YouTube. YouTube took down the video. And what happened? Effectively, Savage managed the speech to not be available right at the time when the advertisement in the New York Times was put up. So Brave New Films basically had their speech that was critical of Savage censored. And when readers of the New York Times went to click on the link in the video, they saw nothing but a sign from YouTube that this video has been removed due to a copyright infringement. Although Brave New Films ultimately sued so they could have its video restored, the damage had already been done. Savage's cynical use of copyright law had silenced his critics at precisely the right moment. Savage, of course, and the gay rights activists on both sides are not alone in exploiting the DMCA to silence speech. Other putative copyright holders have regularly abused the DMCA to silence those who criticize them. Ecuadorian President Rafael Correa has used DMCA takedown notices to suppress speech that is critical of his regime by basically claiming copyright ownership of the footage being released, to show corruption by his government. The English Defence League, a very right-wing extremist religious group based in the UK, has used the DMCA to remove critical commentary from websites that monitor hate group activities. In one case, they used the takedown notice regime because the monitoring group simply used a 16-word quotation from one of the EDL's members without permission. And perhaps most alarmingly and a most unusual example, and this I would call the DMCA takedown hall of shame, a woman who was an ex-wife of basically used the purported copyright interest she obtained from her late husband to prevent online distribution of his suicide note. The move was particularly ironic and troubling because the man, her ex-husband, Chris Mackney, when he took his own life on December 23, 2013, he was in the midst of an acrimonious and lengthy custody battle with his ex-wife, Dina. He left behind the suicide note denouncing her, her family, and lawyers, and he wrote that his last wish was for the world to know what had driven him to suicide. His wife, however, inherited the copyright interest of the suicide note and basically used the DMCA as a way to ensure that the suicide note, a copyrighted work that was previously unpublished, would not be disseminated. In short, because she didn't appreciate her name being dragged to the mud, and the First Amendment precluded other action other than copyright law to prevent that, Ms. Mackney used the DMCA as a vehicle to basically prevent online distribution of the suicide note by her husband, a note that placed responsibility for his untimely passing squarely on her. In short, she used the DMCA to defy her husband's last dying wish. Now, this is not the only incident that belongs in the Hall of Shame. Another almost comical example came up last year when Guns N' Roses, shortly before their reuniting tour in the summer of 2016, started to send some unusual DMCA takedown notices. Lawyers for Axl Rose sent DMCA takedown notices to take down photos of certain photographs that showed Axl Rose to have gained a certain amount of weight. You can see one of those examples reproduced here. Basically, the DMCA was used as a basis to claim copyright ownership in these photographs, which, by the way, had not been taken by Axl or any of his employees, but rather by photographers standing in the special press zone of concerts who had allegedly signed on to a copyright transfer of all copyrights to Guns N' Roses or Axl Rose. These assignments were used as a predicate to bring DMCA claims to remove materials that showed Axl Rose to be less than the fit and suave man that he used to be, to take those offline. So in short, we see great abuse of the DMCA. There is currently a case that is currently being considered for cert before the Supreme Court case that brings these issues to a head. The case is fairly famous. It's called Lentz v. Universal. In it, there is a woman who records her baby dancing to a famous Prince song, Let's Go Crazy. Universal and Prince did not appreciate the use of Prince's work without authorization. As a result, took down the video from YouTube. She, however, got lawyers, counterclaimed, and in fact affirmatively sued Prince under a section of the Copyright Act called Section 512F. She basically claimed under 512F that she should be entitled to damages for the false takedown notice sent. In other words, the takedown notice did not account for the fact that this was likely fair use. Now, in fact, Section 512F of the Copyright Act provides for a cause of action against those who serve takedown notices that are improper. Okay? However, the Ninth Circuit, in adjudicating this case, kind of came up with a split decision with respect to how 512F will be interpreted. It gave a victory to copyright holders in some parts, but also users in others. First, the court did seem to give a victory to users by saying that anybody who serves a takedown notice must, in fact, consider fair use before they send a takedown notice and state the materials are infringing. However, the second part of the Ninth Circuit's ruling eviscerated any value to users that came from the first part of the ruling. Why? Because the court held that the intent standard for liability under Section 512F was subjective rather than objective. So in other words, the notice had to be sent with subjective bad faith, not objective bad faith, or else liability could not be attached. In the words of the court basically held that 512F was unlikely to ever provide relief to aggrieved recipients of takedown notices. Why? To be clear, if a copyright holder ignores or neglects our unequivocal holding that it must consider fair use before sending a takedown notification, it is liable for damages under Section 512F. However, if a copyright holder forms a subjective good faith belief that the allegedly infringing materials do not constitute fair use, we are in no position to dispute the copyright holder's belief, even if we would have reached an opposite conclusion. In other words, this basically gives rights holders and takedown senders a virtual Kool-Aid defense. If they believe that something is infringing and that effectively the fair use doctrine doesn't apply in this case, even if that's objectively unreasonable, they cannot face liability. Given that there's a wealth of case law that suggests that any use of a copyrighted work, no matter how de minimis, is actually an infringement, they can always rest their case on those limited cases and say that they had a subjective true belief that it was infringing. As a result, they won't face Section 512F liability. The fact that 512F is in the DMCA speaks to the fact that Congress was concerned that DMCA could be abused in ways that had nothing to do with the vindication of copyright interests. 512F's enervation, based on its interpretation by the Ninth Circuit in the Lentz v. Universal case, as well as in other cases, suggests that reform is needed in order to recalibrate the DMCA as a way of balancing the rights of legitimate copyright holders who are vindicating their economic interests versus the rights of users who are making use of copyrighted material for fair use and should not be censored by putative copyright holders who are disingenuously drumming up copyright claims as a way of shutting down the speech of their cultural and political opponents. As our examples regarding the DMCA have shown, reform is needed. And that reform could go to Section 512F. Specifically, the standard could be changed to an objective rather than subjective good faith standard. After all, as the lower courts in Lentz v. Universal admitted, the subjective bad faith requirement makes it all but impossible to prevail on a Section 512F claim. Quote, although there may be cases in which such considerations will arise, there are likely to be few in which a copyright owner's determination that a particular use is not fair use will meet the requisite standard of subjective bad faith required to prevail in an action for misrepresentation under Section 512F. However, reform of Section 512F only attaches to issues that involve the DMCA. What about the wealth of copyright litigation that occurs actually in the courts as opposed to the informal processes of the DMCA? How do we address those? Well, let's talk about some of the problems facing litigants in copyright infringement actions. And building on our example from the Maya v. Monge case, let's consider another case of Irina Shevaldina. Irina Shevaldina is a blogger in Florida, and she wrote a series of articles, caustic articles, on her blog charging Ronan Katz, a noted Florida businessman and minority owner of the Miami Heat, with immorality and illegality in his commercial affairs. In doing so, Shevaldina used a photograph of Katz to identify him for her audience. Well, Katz sued, claiming that he owned the copyright to the photograph and that Shevaldina had engaged in copyright infringement. Shevaldina tried to have the case thrown out of court on an early motion to dismiss, but the court declined to address the fair use issue at the motion to dismiss stage, claiming that fair use is a deeply factual question inappropriate pre-discovery. The court expressly declined to follow prior precedent actually supporting adjudication of the fair use defense and claimed that this was, quote, it is, quote, a general rule that fair use defenses are not ripe for determination before the summary judgment stage, a rule that, in fact, many courts do, in fact, operate under. Katz's suit therefore marched on, despite the fact that it was a transparent attempt to drum up liability against Shevaldina for her speech-related activities on a matter of legitimate public concern. Ultimately, Shevaldina won her case 2 years later when the 11th Circuit affirmed her fair use defense resoundingly. However, she had to bear the costs of the litigation from a multimillionaire for 2 years simply because she dared criticize him and in the process used a photo that ginned up a weak copyright infringement claim that was subject to a strong fair use defense. In an even more politically charged example, consider 4 Navy SEALs versus Associated Press, a case from 2005. In the case, 4 military personnel sued the Associated Press and a reporter when, in the wake of the high-profile Abu Ghraib scandal, they ran a story that alleged the SEALs had abused Iraqi prisoners. Among other things, the story ran some photos to provide evidence of the abuse. The photos showed the SEALs sitting on top, lying on top, or stepping on detainees, some of whom were hooded. And they depicted military personnel pointing firearms at a prisoner's bloody head at point-blank range. The military SEALs claimed that the publication of the photos violated their right of privacy and that there was an infringement of their copyright interests. Now, what's interesting is the procedural posture of the case. The court immediately dismissed the privacy claims. Why? Because of the newsworthiness defense, and did so on a motion to dismiss. However, the court declined to address the infringement claims or dismiss them because, again, the court said fair use is an affirmative defense and is inappropriate for adjudication at the motion to dismiss level. The differing results on the privacy versus copyright claims in the Navy SEALs case show that, in fact, there is an issue with copyright claims that is not being addressed. Specifically, the privacy claims, which were grounded in state law, were also subject to, under California law, what is called its anti-strategic lawsuits against law against strategic lawsuits against public participation. It's anti-SLAPP statute. Anti-SLAPP statutes, of course, provide early adjudication of cases that are meant to stifle participation, public participation. And in California, along with some other states, cases that are eligible for anti-SLAPP have been broadly interpreted to involve any case that effectively is trying to suppress First Amendment rights on a matter of public interest. The defendants in the Associated Press case were able to subject the privacy claim to an anti-SLAPP motion as a result bringing about quick adjudication and also an automatic grant of fees against the plaintiff if the plaintiff could not show a significant chance of prevailing on the merits, a probability of prevailing on the merits of the claim. In other words, the anti-SLAPP statute provides a strong deterrent because it provides quick resolution of matters and forces a plaintiff to proffer up evidence to make out a probable claim or face a grant of automatic fees. By sharp contrast, as a federal cause of action, the copyright claims enjoyed immunity from special motions to strike, such as the anti-SLAPP statute. As a result, the infringement claims prevailed, or actually didn't prevail, but they survived, despite their similarly subject nature. Based on this case and other cases, one might argue, in fact, that an important reform to the disingenuous use of censorious copyright cases might be the adoption of a federal anti-SLAPP statute. Basically, federal anti-SLAPP statute would mimic state anti-SLAPP statutes. In other words, this anti-SLAPP could be brought, a motion could be brought on cases where the cause of action arises from, quote, the conduct and furtherance of the exercise of the constitutional right of petition or the constitutional right of free speech in connection with a matter of public issue or an issue of public interest. Anti-SLAPP vehicles allow victims of meritless litigation to dispose of lawsuits early, and the grant of automatic fees to prevailing defendants makes plaintiffs think twice before bringing such litigation in the first place. Now consider how the anti-SLAPP suit might have worked in, a procedure may have worked in some of the copyright and censorship cases we've identified. California's anti-SLAPP law defines matter of public interest very broadly, and it literally encompasses, quote, any issue in which the public is interested, including matters that may be between private parties and even tabloid fodder. Because copyright and censorship cases characteristically involve activities that advance the expression of basic facts or comments on basic matters of public interest, these suits would undoubtedly qualify for anti-SLAPP treatment under the federal provision if it were similarly worded as California's. So, the infringement claims in the 4 Navy SEALs case, which involved allegations of torture by members of the armed services, would involve a matter of public interest and the suppression of speech related to it. They would be subject to the anti-SLAPP statute. The matters in the Katz v. Chevaldina case, again, allegations of corruption against a prominent real estate developer, would be subject to anti-SLAPP. The Savage suit, a hate-filled rant by a prominent radio talk show host and political commentator, subject again to the anti-SLAPP suit. And the Monge case, marital status of a major Latin celebrity, again, subject to an early showing of the plaintiff of a probability of prevailing on the merits. Thus, in most cases, the availability of anti-SLAPP relief could deter these kinds of censorious cases. In the Navy SEALs case, the court would have disposed of the copyright claims just as it did the privacy claims under state law. The Associated Press and its reporter would not have faced the continuing threat and expense of litigation on a disingenuous copyright claim that was clearly aimed to suppress reporting on a serious matter of torture and important allegations against military officials. In Katz, the blogger wouldn't be forced to defend herself for 2 years against disingenuous claims of copyright infringement by a real estate mogul who did not appreciate the blogger's allegations of commercial impropriety. And in Savage, the automatic assessment of fees would have at least served as a powerful vehicle to deter the radio talk show host for his subsequent successful action in suppressing criticism by him by Brave New Films. Now, an anti-SLAPP statute wouldn't be a cure-all remedy. And in fact, we'd also have to be careful to subject certain claims, not all copyright claims potentially, to anti-SLAPP statutes. In fact, almost all copyright claims have the ability to adversely impact freedom of speech in one way or another. But anti-SLAPP eligibility could be carefully circumscribed so that it does not impact cases where a copyright holder is legitimately bringing a copyright suit to vindicate its economic interests. So to take 2 examples that we've mentioned before, the Prince v. Universal case and the case involving the Harry Potter Encyclopedia. In both of those cases, no matter how one might feel about the plaintiff's motivations or whether the case was a good idea, The interest was not suppression. Prince and Universal did not care if this woman was making any kind of political speech. They were basically trying to control the economic value of their work. Okay? They may have been engaged in bad form action, their action may have been ill-advised, or it might have been avaricious, but it was not censorship. Similarly, Warner Brothers, when it brought suit against the makers of the unauthorized Harry Potter encyclopedia, they were not trying to censor speech about Harry Potter. They were concerned with controlling the market for Harry Potter and the exclusive right to create definitive Harry Potter tie-ins. Okay? In those cases, there was not a censorious motive. The desire was not to suppress the defendant's particular message or content. Okay? Motivations, though, can be very difficult to depend, but we can use a proxy, arguably, about potential bad faith, and that is whether the plaintiff lacks a legitimate economic motivation to preserve a rightful market for its licensing of the work. Thus, we could limit anti-SLAPP relief to instances that bear the hallmarks of censorious motivation, specifically a two-part test. One, where the plaintiff lacks a legitimate economic motivation to preserve an established market for the licensing of its copyrighted works, and two, whether the defendant's use of the work at issue advances the expression of basic facts or comments on matters of public concern. If these two elements are met, then anti-SLAPP can apply. One other suggestion bears mentioning as well. Now, very famously, courts have largely immunized copyright claims from the First Amendment. However, it's important to note that in other contexts, specifically other tort claims, courts have not been so reticent to invoke the First Amendment. Consider New York Times v. Sullivan, the 1964 case that very famously checked defamation claims by putting a First Amendment limitation on them. New York Times v. Sullivan has been applied initially to public officials, but also expanded to any speech that is allegedly defamatory involving a public figure. New York Times v. Sullivan has been extended, not just to defamation, but as also to all manner of various tortious claims, including claims for false light, intentional infliction of emotional distress, and invasion of privacy claims. These doctrinal innovations had a common goal: to prevent courts from being used by public individuals as a means to wield the power of the state through the imposition of legal liability to effectively suppress speech on matters of public concern. However, the courts did not go far enough, arguably. They left a giant loophole. They haven't subjected copyright, arguably a form of tortious conduct, to the same checks that defamation, false light, intentional infliction, emotional distress, and invasion of privacy have. This blind spot in courts' jurisprudence has led to the wave of censorious infringement litigation that we have seen in recent years and have documented. The adoption of a New York Times v. Sullivan-like check on censorious claims, specifically a check where that invokes a New York Times v. Sullivan check when you have matters of public concern where the plaintiff seeks to vindicate values outside of the established market for their licensed work, could serve as an important step towards combating censorious infringement litigation. Now, it's worth noting that in other intellectual property contexts, courts have developed independent First Amendment checks in certain circumstances. In trademark law, for example, despite the existence of statutory fair use defenses, federal courts in recent years have innovated by adopting the common law Rogers v. Grimaldi test, which basically immunizes any maker of an artistic work from trademark infringement liability so long as the artistic work uses the trademark in a way that is artistically relevant, as one court has put it, anything above 0 counts, and does not suggest expressly any kind of misleading nature of sponsorship or endorsement. In addition, in the right of publicity context, courts stemming from California to other states have in fact checked right of publicity claims significantly by developing the transformative use test from the famous Comedy 3 v. Satirup case from 2001. In that case, the California Supreme Court found that any transformative use of a celebrity's likeness, regardless of any other factor, was a 100% excuse from liability under the right of publicity, a far more generous defense than that which is applied under fair use. Copyright's moment for an explicit First Amendment check has come. Several hundred years ago, when copyright began, it was actually a law of censorship. With official chartering in 1557, the Worshipful Company of Stationers and Newspaper Makers, later known as the Stationers' Company, a guild of London booksellers, implemented a register system. With royal backing, this system enabled the company to prevent the publication of and to seize and destroy any unauthorized works not duly authorized by the company and implicitly by the Crown. The entry of a book in the register gave the publisher thereof a copy, and they enjoyed attendant rights thereto. This right became known as copyright. For a century and a half, the company and the Crown combined to use copyright as effective as a tool of censorship in England. Unfortunately, however, copyright is threatening to come full circle. The ubiquity of infringement, the severity of penalties under the Copyright Act, the immunity of copyright from the First Amendment, all three of these facts have combined to create ideal conditions for private litigants to exploit the state-granted monopoly of copyright to censor the expressive activities of their adversaries. Though not insubstantial, efforts by the courts to curb this trend have ultimately failed and have sparked the need for reform. Such reforms should not only vindicate the expressive rights of the political and social adversaries who found themselves on the receiving end of meritless takedown notices and infringement litigation that is meant to censor their speech. In the process, these reforms should also strengthen the functioning of the copyright regime for legitimate rights holders seeking protection of their appropriate copyrights.